So that was one very informative. I think it was, very informative for me personally, on what all aspects of GST that need to be considered. Let's move on to our next very interesting topic. Again, a much talked about topic, which is Real Estate Regulations Act. And let's try to understand the interplay of legal framework and RERA regulations. So our next panel, let me introduce the moderator of this session, Mr. Ajay Sharma, Managing Director, Valuation Services, Colliers, India, who has over 15 years of experience undertaking real estate valuation and advisory across India, Sri Lanka, and Maldives. He has been advising clients ranging from private equity funds to government agencies and has led teams of valuation and advisory engagement and has consulted for smart city projects, transport node modernization program under Ministry of Transportation, airport landside development, etc. Mr. Sharma, a very warm welcome to you. Let me now introduce our speakers in an alphabetical order. I welcome Ms. Aruna Kumari, Senior Partner, Kocchar and Company, a seasoned lawyer having experience of 20 years in the area of real estate laws, litigation, corporate and commercial laws, intellectual property and employment laws. She's a counsel to many MNCs, real estate and infrastructure companies, IT giants and banks, having extensively advised such clients on various transactions such as mergers and acquisitions, leases, joint development ventures. Our next expert on this panel is Mr. Farid Karachiwala, partner, JSA Advocates and Solicitors. He has been practicing law since 2000. He is also an advocate on record of the Supreme Court of India, and he regularly advises business houses and realtors on all aspects of real estate transactions and strategizing acquisition and sale of immovable property. Let me introduce our next panel member, Mr. G. Vivekanand, partner, Indus Law. He has conducted litigations, including arbitrations for multiple developers as well as non-developers, both on land disputes, contractual disputes, and against statutory violations. He has succeeded in obtaining a landmark ruling against the time-barred demands for stamp duty and declaring the time limit for demanding any deficit stamp duty. Our next member of this panel is Mr. Santosh Pandey, CEO, Sarthak Advocates and Solicitors, whose career in law has been preceded by a long career in FMCG companies and consulting with SMEs to compete globally. His practice areas include legal advisory, consumer protection, real estate, and dispute resolution. Our next and final member is Dr. Vijay Satbir Singh, IAS retired and former MahaRERA member. He joined the Maharashtra Real Estate Regulatory Authority in 2017, and prior to that, he was the additional chief secretary with the government of Maharashtra. He pioneered several reforms in public administration and simplified many procedures and permissions to promote the ease of doing business. So this is our expert panel, and Ajay, let me hand it over to you now.
Thank you, Sapna. Before we get into the panel discussion with this elite forum that is gathered today, I would just like to go into the, what RERA is and what has happened since it has been introduced. So, every point of time, laws are made to define and regulate evolving social and commercial relationships in a society. And, the legislature is actually elected by the populace to frame, pass, and amend laws. But many times the judiciary is the one that interprets, upholds, or strikes down even such laws, when on which basis resolutions in the future become are sought by the civil society. So, given this complexity that ensues due to the multiple overlay of multiple laws that exist on any given subject, the various stakeholders, especially in the judicial system, have an important role in interpretation and understanding of these interplays of the legal framework and the constitutional validity of the provisions in each of such laws. So that this is very important. Property laws are among the most important in the world, and in India we have property laws dating as back as 18th century that are still applicable and referred to today. Among such enactments, recently, of course, the Real Estate Regulation and Development Act 2016 is the focus act for today. and its interplay with the other pre-existing legislatures that are there. So that's something that we will talk about. We will try to discuss the impact that this act has had and the ambiguity that exists because of this multiple overlay that's there. I take pleasure in welcoming Advocate Farid Karachiwala, Dr. Vijay Satbir Singh, Advocate Santosh Pandey, Advocate Aruna Kumari, and Advocate Vivekanand to this forum. Thank you for being here. We would like to understand from you how the various judgments, orders, and interpretations therein can enlighten the viewers today on this forum on the complex interplay and the conditions that push or limit the application of the law. RERA was, of course, passed in 2016, and interestingly, we had multiple cases filed across the high courts in the country challenging the validity of the law itself, and which was then, brought down it was all compiled and brought to the Bombay High Court bench to look into the validity, and of course, it passed orders in 2018 upholding the constitutional validity of RERA. So that's what the journey, the act had to go through before, it started seeing some kind of an impact. So today, RERA has been notified in multiple states except for Nagaland as of January 2023. We have 3 states which are yet to establish regulatory authorities, while 4 states are yet to have only an interim regulatory authority. The notable exception in this is Telangana, because all other states which do not have an interim authority or a regulatory authority are all in the Northeast. Only Telangana is one such state which still is going through this. We still don't have websites for 6 different states, which provides the crucial access to most of the stakeholders. In this, again, West Bengal is a notable absence in this. 10 states are yet to appoint adjudicating officers. Now, the total RERA cases that have been disposed as of January 2023 is almost close to 106,400 odd cases, of which nearly 36,500 odd cases were disposed between 2021 and 23. So that shows that the improving effectiveness of the RERA tribunal, the RERA body in multiple states. Almost 99,280 projects have been registered under RERA across the states, and about 56% of these projects were registered after 2019. Again, RERA registration has been highest in project registration has been highest in Maharashtra, followed by Tamil Nadu, Gujarat, I think Karnataka, and then probably Delhi NCR and Telangana. The RERA agent registrations also have grown significantly since the law has come. So today, I think about 71,500 odd agents are registered under this law. Given all this, the first question I have to Dr. Singh, because he has been an ex-RERA member, and there's no one better placed than him to tell us how effective do you see, how effective has been the law in its implementation? Of course, you have been a MahaRERA member, but how do you see the implementation effectiveness across India?
Thank you, and good evening, friends. It's a very good question, and I would like to say that although the picture is different from state to state, I can talk about Maharashtra, and the feedback which we used to get is that it has been very effective, and we moved from an era in which the real estate was totally unregulated to the one in which a regulation started. The sector was entirely unregulated before that, although we used to have MOFA in Maharashtra. And also in 2012, we also passed another legislation, Housing Regulation and Development Act 2012, which was repealed after RERA came into effect. But by and large, the sector was entirely unregulated. We used to have a system of getting regular feedback from the home buyers and others. And we found out that they were very much satisfied with the working of RERA.
So I think the numbers also talk, given the number of cases that were disposed of and number of cases that were registered and disposed of. So of course, they do talk about the effectiveness. But one quick question I had on this, Dr. Singh, is that the uniformity of the RERA provisions across states, the Model Act is there, but multiple states have multiple provisions and it's not uniform. So this has been a hotbed of discussion that's been happening. It went to as far as the union government being directed by Honorable Supreme Court of India that, you should have a model, agreement to be put in place, buyer's agreement to be put in place that has to be followed by all the RERA authorities across the states. It had also come up with the thing that, the provisions have to be uniform across the states. So, given this, how specifically do you, given these conflicts that are there, in fact, to the extent that I think HERA in West Bengal was declared unconstitutional by Supreme Court because it had provisions which were going against the Model Act. So how do you see this will happen and what steps are being taken across for this uniformity to set in?
Well, it's a central government act and it's the same throughout the country. It's applicable to every state except J&K. And all the states have taken action to establish authorities under the act. Every state has its own rules and regulations. Now, when it comes to the implementation of various provisions of the act, in some states, the rules were found to have diluted some of the provisions, which is not good, for the intention of the overall objectives of the act. And it's there that the Supreme Court had given directions. Like, when one of the directions, as you have cited, the Supreme Court asked the central government and the state governments to have a model agreement for sale. Following that, in Maharashtra, one committee was constituted, and I was the chairman of that committee. And we drafted not only one model agreement for sale, but also model allotment letter.
Okay.
So model allotment letter is also there, and model agreement for sale was also drafted. And we sent the copies of these documents to the Government of India, and also we, started action to make these copies available to the Honorable Supreme Court. Now, this all happened after the intervention of the Honorable Supreme Court and the directives given by the Government of India. Now, there have been some issues with various states. In some states, the rules were different, and some rules were not strictly in accordance with the provisions of the Act. There have been many instances, but by and large, what I found out is that states have started taking action and the authorities have been constituted. They're working very well.
Okay. Now the question is to Advocate Vivekanand. In continuation to this thing that, where we have a direction to have a model builder buyer agreement, which is with the critical provisions of RERA that has been directed by the Honorable Supreme Court. What, according to you, should be part of this agreement, the critical part of this agreement, which we cannot be overseen by the buyer? And do you think currently the agreements that are being executed are sound and already are mirroring these proposed models, or there's a lot way to go before we get there?
Foremost, thanks for giving me this opportunity, and good evening, all. After enactment of RERA, some of the states have provided model agreement in their rules, like state of Tamil Nadu has provided model agreement in the part of rules, and only caveat or only exception where the rules permit you to changes on the commercial terms and the timelines. Other things are more or less frozen and more or less are neutralized between buyer and the promoter. and to, for example, extent of refund of on cancellation, the grounds of cancellation, all those things have been finalized. And after RERA, to some extent, the states have incorporated the model agreement and they are following to the extent possible. And as you're aware, the Supreme Court also has now suggested to Ministry of Housing and Urban Development Department to formulate an agreement under the RERA, and where there is a suggestions to split the contents or the clauses into two parts, where it is split into A and B series. A series are non-negotiable and B series are the clauses which can be negotiated. So A series may cover like covenants, representations, disclosures, all those things being part of the agreement which cannot be negotiated, and it has to be in the format as agreed. B series may have other clauses like commercial agreement, timelines, specifications of the building or the development, whatever it is. And B series may also have other extra or additional clauses which is particular and customized to the project. So to that extent, yeah, there is a progress. And see, RERA is a new act and it's hardly 6 years old. And now various mechanisms are worked out to make it more effective and more workable neutrally between the promoters and the buyers. Though it is a regulating registration and the regulation has to be balanced between both home buyers and this thing, it is over a period of time, it may get more regularized and regulated by way of agreements and other things. The model agreement is in place. Yeah, it is in the progress of getting finalized and hope to get it done fast.
Yeah, thank you for that, Dr. Vivekanand. Advocate Santosh Pandey, one of the important aspects of RERA is actually recovery, right? So, and how this recovery happens. So, Section 41 of RERA is a decisive instrument on this recovery part, how to enforce recovery. Now, what is the mechanism that the recovery done so is not measurable against the penalties that have been enforced upon the buyer or the developer, and what further steps can be taken if the developer defaults on these recoveries, orders of recoveries that are made on them? So this is especially the reason why we are discussing this is basically because there are multiple debt recovery laws also in the country, right? And their applications can come, and we have case laws where a RERA order has been challenged under a different debt recovery law as well. So what is your take on this part?
So first of all, good evening to all of you, and thank you, Ajay. As far as Section 40 subclause 1 is concerned on the recovery, I think one of the areas which under the RERA provisions has been said to be ambiguous by the Honorable Supreme Court is in the new tech promoters and developers, the latest judgment. And the Supreme Court has gone on to kind of clarify that it is a recovery of not only the interest and penalties, but the recovery of the principal as well. I mean, that has to be read harmoniously.
Right.
Coming back to the situation of recovery, I mean, I'll be honest with you, while it is only 6 years since the time the provision has been enacted, execution has been one of the areas which has been lagging behind, and quite substantially so, having been part of litigation in Haryana as well as in UP. Execution of RERA orders is an area where I think the authority will be looking very, very carefully. I mean, as you know, RERA orders are equivalent to civil court decree, right? And any arrears, any non-compliance has to be recovered as the arrears of land revenue, right? I mean, there has to be an execution application that needs to be filed based on which a recovery order, recovery certificate is issued. I mean, across states, rules vary. Previously, up until maybe 6 months ago, the execution application in Haryana was being enforced by the authority themselves. Post the new tech development, rules have slightly changed. Like it used to be in UP, where based on the recovery order, the same recovery order was then transmitted to the district administration, who will pass it on to the Tehsildar, and who will follow up on the recovery to get the money and then pass it on to the aggrieved party. Now the question is that in land revenue arrears, there is a very old law, Revenue Recovery Act of 1890. I mean, that's the central legislation, and state rules are there, right? But on the basis that it is a civil court decree, any RERA order is civil court decree. I mean, we have to follow the law. I mean, that's the only one. I mean, of course, there are RERA orders which are challenged in the appellate tribunal. From there, they can go to High Court, and people have gone right up to the Supreme Court. Notwithstanding the fact that Section 43, subsection 5 has been upheld, where any promoter has to pay 30% or more of the penalty, and maybe in some cases 100% of the interest amount, right? So I don't think that once a civil court decree RERA order is, then there is any need for any further mechanism that is required. What is required is enforcement of the RERA orders, and that's where it should be. That's what I think. The question, however, is that what happens when the promoter goes into insolvency?
Correct. That's right.
That has been the problem. I mean, there have been situations where an LRT has got an order from RERA, which has been upheld by the appellate tribunal, okay, or the promoter has not gone into appeal against that order, and before that, insolvency proceedings have started. And then what happens is that the LRT is supposed to file their claim with the RP, right? And then, of course, once it gets into insolvency, all the legal proceedings, against the promoter, a moratorium is, open, and there is no legal recourse anyway. Then one has to wait for the resolution plan of that CIR process that goes on. So, in my mind, the recovery process has to be, once that RERA order has crystallized, the law of the land which is existing will take its course.
Very interesting point. In fact, this is the interlay and an interplay of the legal framework that this entire forum is all about, right? So how this IBC and SARFACI acts, they have been invoked against certain RERA orders that were passed, and the developers have been trying to take shelter under that for not paying the penalties that have been levied under them. I would come to Advocate Aruna Kumari right now. In fact, this just continuation on what Advocate Santosh Pandey was telling. In case where the builder is declared insolvent, we know he has been declared insolvent. It has been admitted into the entire insolvency proceedings. After that, can a buyer still go and seek redressal from RERA? That's one question, in a sense, because he can still have complaints and grievances against the developer. And if they seek the redressal from the authority, is the compensation order that passed by RERA seen as a liability build-up to the bill to this corporate debtor now? Is that a possibility? Or once this proceeding starts, there's no more redressal that RERA can offer to buyers into a certain project where the developer has been declared insolvent?
So, first of all, thank you, Ajay, for the introduction, as well as for sharing this session with me, and also all the participants here, panelists. A very good evening to you all. So, coming to the question now. So Ajay, I would say here I would like to make an assumption, though you have given a scenario where the the builder is declared as insolvent. So because that would close the doors for me to deliberate anything, and that is my answer also. That in case we can imagine a situation where the insolvency proceedings are pending before the adjudicating authority, and in such a scenario, whether during this pendency, whether a home buyer or an LRT can approach RERA is something that we can deal with at this moment. And I would say that when the IBC proceedings are pending, then as it is already dealt, and the home buyers are given the status of financial creditors, so they have a forum open and the platform open for them to get a legal recourse under the IBC as well. However, here every action that that the home buyer wants to pursue as an additional remedy under RERA would be subject to the moratorium as well. So as Mr. Pandey was referring to that, and as Mr. Pandey has said, again, this is again an interplay of all the legislations. So the moratorium would kick in, and the home buyer would not cannot take the advantage or the benefit of RERA. However, there is another scenario where the RERA and the proceedings before RERA have already been initiated. They are pending before RERA, and the insolvency proceedings against the corporate debtor have been initiated by some third party. So that is another scenario where we can discuss. And in this case, in case the compensation is awarded while the insolvency proceedings are pending, in that case, yes, the compensation that is awarded will become a liability, corporate debt or the builder, and it can be recovered as any other debt. However, as we are discussing this interplay of legislations, I would like to take a little divergence from IBC to the Securitization Act, for the Surface Act. So I would like to cite one case law, Union Bank of India versus Rajasthan. So here in this case, the builder defaulted, and he has availed certain project finance, and the banker has taken possession under Surface I. Now, while this is pending, then under Surface I, the banker wanted to proceed with the auction of the property. Then the allottees, the home buyers, they approached RERA, saying, asking the RERA authority to intervene and stay the auction. And RERA has passed orders against bank. Now, banker, this order of authority was challenged before the High Court of Rajasthan, and the High Court of Rajasthan has held that because the banker has stepped into the shoes of the promoter, the order passed against the banker would be valid. So here you can see the interplay, like the RERA as well as the Surface side, and here we can see that the promoter whoever has also stepped into the shoes of the promoter is also liable under the RERA, and RERA has been very effectively implemented in this particular case.
Yeah, just continuing with that, Aruna Kumari, that we took a scenario, and of course we discussed this Union Bank of India versus the RERA authority of Rajasthan. So we did discuss that case law. I wanted to ask you a specific question. See, because many times what happens is a lot of people are taking home loans from a housing finance company and then buying into a project. Now project gets into an inordinate delay, then it kind of goes, then a banker initiates, he says, I want to execute the charge on the project. The project becomes insolvent. Everybody is stuck, right? Up to this scenario, of course, that Union Bank of India case law kind of applies. Now, just going a little beyond that is that because the project is stuck, there could be scenarios where multiple loan borrowers, that is individuals who borrowed from HFCs, could go also into defaults, right? Now, when they go into defaults, the bank has to execute a charge on the units which they bought, right? But unfortunately, this is already under an insolvency, or let us say under Surface proceeding. So how does this recovery work? And is there any redressal at all for an institution at a retail loan level if they have to participate? Because I do understand when you can make it like you gather multiple loans and then the bank makes a representation before the pendency under the adjudicant of an NCLT, and then before the insolvency is declared. But what in this kind of a scenario, how does this work, and what are the legalities and the difficulties that come in?
Yes. So this is a very tricky situation, Ajay, because here the builder is already declared as insolvent, and there is no built up, the proposed built up on which the banker must have lent money even to the the customer. So so this is I think here there will be a twofold action that would be involved, and we cannot really club these two remedial actions that are available to different parties. That is, here we are talking about the redressal for the banker, where the home buyer is also in default. So however, here what comes into picture is the contract between the banker and the home buyer. So that has to be dealt on a different footing. The IBC or the redressal mechanism that is available to either the banker or the home buyer as financial creditors under IBC, and the other mechanism, that redressal mechanism available for the home buyer before the RERA. So
Correct.
here here the banker will definitely have they can definitely enforce the agreement that is entered between the home buyer and the banker, because by the time banker must have parted with certain money, and they can always take action for the recovery of that money. And as you all must be aware of that the other scenario where we said that the builder is already declared as insolvent. So here and we have also seen the this case law wherein the Pioneer Urban Land Infrastructure case, where the constitutionality of this amendment was upheld. During the home buyers as the financial creditors. However, that comes with the qualifications that there should be at least a minimum of 10% of the total number of allottees or the home buyers, or the 100 number. So with these qualifications, yet it is not so effective remedy for the home buyer under IBC, and it would always be a better remedy available for the home buyers only under RERA. See, because what happens the moment this redressal mechanism is sought under IBC, there are only two ways how it is dealt under IBC. That is, either it is revival or liquidation.
Correct.
The moment the revival is is not feasible, is not working out, then it gets into liquidation. And in case the project is almost a 70 or 75% completed, then that would not be a very efficacious remedy to really sell off that asset and take the proceeds. So it is always a best remedy available to the home buyers is only before the RERA.
Advocate Santosh Pandey, you had something to say because you did raise your hand. Any thoughts on this?
Yeah, basically, the situation that you said is a bit of a chicken and egg story, right?
Correct.
Because first of all, the promoter raises finance based on the project, right? And then promoter gets money from the lottee, who in turn goes to the bank to raise finance against the same apartment that has been allotted to them, right?
Correct.
So the consideration in both cases is one and the same. I mean, the provision, I mean, it's a bit of a legacy issue, I must say that. I mean, what has happened with Union Bank of India versus Rajasthan RERA, I mean, takes the cue from the Vikram Chatterjee versus Union of India, where subvention scheme, in the name of subvention scheme, there were quite a few privileges unduly availed of by the promoters and the banking and financial institutions. And clear case of collusion was established by the Supreme Court. My take is that going forward, on the basis that the Honorable Supreme Court has upheld the judgment of the Rajasthan High Court in the Union Bank of India versus Rajasthan RERA, I think the banks will be that much more careful in creating charge on a project, and equally the allottees will they are far more aware now. Now, coming back to the situation, I think Ma'am Aruna Kumari, what she says is that, I mean, and I can give you a live example. So here is an allottee who, under subvention scheme, got money from Bank X. Bank X has also financed the project. And then the project has gone under liquidation. I mean, not liquidation yet, but CIRP has been initiated against that, that project. Now, the only recourse that the two of them have, that is a bank as well as the allottee, is against the promoter. And then, because the CIRP has been initiated, the respective claims are to be filed. Okay, and there is no other way that I can think of. The problem is that the allottees, when they default on their payment, their civil start getting impacted very, very badly. Because under the subvention scheme, the situation was that the pre-EMI payment reimbursement was being promised by the promoters. Okay, so there was a lot of hanky-panky that had happened previously. But going forward, I believe that banks will the potential of collusion between the bank officials and the promoters will be reduced, and that's the only safeguard that we can hope for.
Thank you for that insight, sir. Now, again, coming back to Dr. Singh, what is the jurisdiction of RERA on leasable properties, and how does RERA look on the rights of lessees and lessors? Because this is not much talked about. We generally talk about residential where it is a straight on freehold interest, but on leasable properties, what is? I mean, because you have seen cases. What is your insights on this? And when lessee holds long lease rights, and then they subsequently go for subleasing, or they transfer interest to a third party for the duration of the lease that is left, and if the original lease right was revoked by the lessor, how does this law treat the lessee under RERA? I mean, so this is something that we want to understand. Especially because this comes, a lot of industrial properties today are undergoing to residential developments, right? So these lands are all 99-year leases, and these issues are going to come up a lot. And especially in Noida Authority also only allots the land for a specific period of time. So we want to understand this part.
Well, all the projects in which the land or the building or the apartment is having lease, if it's a long lease, then of course these projects are covered by RERA, have to be necessarily registered. And the leasee is an allottee as defined under section 2D of Real Estate Regulation Act. So in fact, MahaRERA had further clarified that lease beyond 5 years, any lease that is beyond 5 years, it comes within the purview of RERA. Well, as far as short lease, term lease agreements are concerned, like leave and license, or where rent is involved, these are not covered under RERA. Your second question is that what happens in case, the lessor does something to the lease, then of course, the relationship of lessor and lessee is governed by the lease document.
Right.
There, I don't think RERA can step into that and, try to sort out the issues arising out of that,
No, I understand. So you're quoting now that Contract Act will come into play here, and more the provisions of the Contract Act will come. But I have now a question to Advocate Karachiwala, because it's just taking that a little step forward, that particular question, is that assume that you have a JDA that's in place, right? You have a JDA that's in place. There's a development partner who's developing the land, and a certain type of agreement. So because there are multiple structures in JDA, but both have kind of an equity position in the project. There's an aggrieved buyer. He has raised he has put in a case, and it goes against the development partner in the RERA forum. And now this happens multiple times. The JDA gets cancelled. Then how is the aggrieved buyer protected, and what are the remedies that are available for him, and which parties in the JDA agreement will have to necessarily fulfill these penalties that have been brought upon by RERA. So this is the question I have for you.
So, hi. Very interesting question. I think there are two kinds of issues that we look at when we look at this question. One is that between the JDA partners, there's an ongoing dispute, which is before a different forum. And while that dispute is ongoing between the JDA partners, there is an aggrieved allottee who's aggrieved by the fact that this project is not getting completed. And he goes to the RERA forum in order to enforce remedies that the RERA Act actually provides. Now, these are situations which are very normal, and I think Dr. Singh would have come across this, quite a few number of times when he was presiding as member. One is that any dispute between the two JDA partners, because they both get categorized under the definition promoters under the RERA statute. So the JDA partners would typically be the landowner, that would be one partner. The second would be the developer, who would join hands with the landowner in order to make the project. Now, whatever differences happen between the landowner and the joint development partner, that would either be in the civil court or it would be before the arbitrator, etc., etc. But so far as an allottee is concerned, under an agreement or an allotment letter, any private dispute which is there between the two promoters should not in any manner hamper the rights of the allottee or the number of people who have bought apartments in that project. We've seen this a number of times, and in fact, there's a judgment which has been passed by the MahaRERA appellate tribunal in the case of Tupe developers versus Bhansali Infotech, where it was very, very clear that in this case, actually, because there was a sharing of revenue between the two promoters, the RERA forum, the RERA as well as the appellate tribunal actually insisted and passed an order saying that since both of them are going to be sharing the revenue, the project cannot be disturbed. Their private disputes can be decided by the other forum, but the rights which the allottees have still to be enforced by them. Both of them are going to get revenue on the basis of the project completion, so the project still has to continue. So the allottees' rights actually get protected, notwithstanding any private dispute that is ongoing between the JDA partners. And that is what the RERA forum and the appellate tribunal have consistently held.
Okay, very interesting to note, because also I do understand sometimes the redressal mechanisms also reach the consumer courts under the Consumer Protection Act also. So this question, I just have to pass it on to Advocate Santosh Pandey. We know this in MRMGF Landco and Aftab Singh matter. The buyers actually went from both the Consumer Protection Act angle as well as under the RERA Act. Now, obviously, a lot of people wouldn't know this unless and until they're getting into a situation and a lawyer is able to guide them. But what does this mean for a home buyer, and what limitations they should be aware of? Because now they see that there is a possibility to go under both statutes, but what are the limitations they should be aware of? That to what extent they can use these statutes?
Okay, so as far as home buyers are concerned, I think it's a problem of plenty, if I may use that word. The Honorable Supreme Court has gone on record saying that home buyers have got concurrent remedies under Consumer Protection, RERA, and IBC. Not to forget the arbitration. While in that landmark case that you have just referred to, MR versus Aftab Singh, it originated from the judgment of the NCDRC, where the issue was that under the contract, the dispute had to be adjudicated and settled under the arbitration. And then the Honorable Supreme Court upheld the NCDRC judgment that when you have got specific laws, special laws, and sectoral laws like Consumer Protection and RERA, and if one party wants to go to these seeks the remedies under these laws, then arbitration cannot be forced. Okay. So now coming back to the situation for the allottee, I recently came across a judgment of Honorable Delhi High Court, where one of the parties, an allottee, was pressing for arbitration, whereas the developer was looking for RERA remedy, in a dispute. So the question is that what a home buyer should be doing. in my opinion, RERA is being sector specific, has got advantages over the Consumer Protection Act, in the sense that the Consumer Protection Act is not available. I mean, one of the defenses that has been taken is that, the promoter said that the allotment was done or obtained for investment purposes. And the moment it becomes an investor, under Consumer Protection Act, then the matter falls, because that is only for the use, for the consumers. Whereas in RERA, I think Dr. Singh will confirm that Maharashtra RERA came back and said that investors under RERA, as long as they're allottees, they also have a remedy, right? So in my opinion, RERA is beneficial. I mean, both are beneficial legislations, but it has got wider scope under RERA than Consumer Protection.
Right. Advocate Karachiwala, this is a problem that you find in most cities, especially in a city like Mumbai, right? Conveyance. Societies have, the buildings have been built, societies formed, associations formed, but the original landlord, who is the developer, has not conveyed the land to the society and association. 30-40 years have gone by, and suddenly you have this redevelopment requirement that comes in, and then suppose the original developer is not there. You have to find specific, curative measures to be taken for the conveyance to be deemed conveyance to happen. Then subsequently get into redevelopment and all those things. What I want to understand is what issues generally buyers will find. So because obviously when the redevelopment is happening, pre-sales and things, what issues do buyers have to be very aware of? And if the redevelopment goes ahead without solving these conveyance issues, especially for the people who are already who are going to be rehabilitated, or the original owners of the shareholders in the society, if they're getting a new unit, if things don't go accordingly as planned, then what is the mechanism that they have to seek to kind of get a remedy for themselves?
Right. So very interesting. One is that without conveyance, you can do a redevelopment agreement, but the redevelopment agreement will not be pursued, because at least in Maharashtra, we require three things which are very, very important for any plans to get sanctioned. One is that you need to show that you have title to the property. Two, your name needs to be mutated into the revenue records, which in the Bombay city is the property card. Third, there will be a title certificate which will be required to be submitted to the municipal authorities in order to show that these plans are being submitted by an entity which has basically given rights to a developer for the purposes of redevelopment. So conveyance is absolutely necessary. Where a builder has not given conveyance, then the procedure is that there's a provision under the MOFA Act, which allows you to go and apply for deemed conveyance. There's a procedure which is set out before the deputy registrar, and you can go and get this thing done. The issue is, again, that after you have got this conveyance, and when you go and move before you register the project, and you ask and you try and sell premises, what are the remedies of people who have to be rehabilitated, as well as people who are now going to be the new purchasers in units which are going to purchase. So they will have to deal with it separately, because there are two judgments passed by very recent actually, and which follows a 2019 appellate tribunal judgment, that so far as rehabilitation units are concerned, because what they do is that they enter into something which is called as permanent alternate accommodation agreements. Those don't get covered under the provisions of the RERA. And those are not people who can actually go, because the word allottee would mean a sale of premises. And when you are actually giving them premises in lieu of something that they already had, it is not construed as sale. So in Maharashtra, at least, we've seen judgments both by RERA as well as MahaRERA, which basically says that you can't really go before the RERA forum. You will have to enforce your remedies under the agreement that you have entered into. So that is so far as rehabilitation units are concerned. With respect to units which are freshly sold, those will be considered as normal units, etc. You look at the agreement, you see where the violation is, and you see as to what is it that the promoters have not been doing, the developer has not been doing, and you can enforce your rights in accordance with the provisions of RERA, and the RERA will, take care of your grievances. No issue there.
Yeah. Very interesting. So I also wanted to pose this question again to you, Mr. Karachiwala, because there has been talks of repealing the MOFA, right? And there's been a lot of resistance against repealing of the MOFA because RERA does not necessarily cover most projects, which are, at least retrospectively, they don't cover a lot of projects where there has been such issues. What is your take on this? Because there has been a lot of push and pull on this particular matter. And how do you see this will result? Are you seeing this will have a kind of amendment level effect on RERA going forward if MOFA is repealed, or you're going to see that no, it will still continue and both will coexist and remedies can be sought under both for people?
No, so, very interestingly, I think although there's been a lot of discussion on this, we have to look at these two statutes to actually, go side by side and to complement each other. So where there are provisions of RERA, MOFA doesn't apply at all, because RERA being a subsequent statute, a more specific statute in terms of regulations, providing much stricter timelines, the RERA will apply. But there are certain aspects which are not really set out in RERA, and that is why you need to actually complement both the statutes and try and see if they both can work hand to hand. And this is where I think the problem, see, RERA has been now there for only about 7 years. We are still seeing, tremendous growth in terms of what things are happening. But if you ask my frank view, is that there are provisions in MOFA. There are provisions where you can actually go before the criminal courts in case, developers don't do certain things, which is specifically set out in the provisions of MOFA. The standard form of agreement, of course, is then both, and you would follow the RERA agreement. But this concept about deemed conveyance, what happens in respect of older projects which are not registered, I think is going to be a very difficult situation, because for the purposes of ensuring that the grievance of those people who have bought their apartments or their flats before the coming into force of RERA will really have to look back upon the MOFA legislation in order to enforce whatever remedies is there. So my personal view as a lawyer, as well as a person who would buy an apartment, is that MOFA should not be repealed. These are two statutes which need to go hand in hand with each other. They complement each other. And wherever you have a remedy available, one of these two statutes would come to your help.
Okay, thank you for that insight. Dr. Singh, this is a question for you, especially because you're from, a lot closely have seen Maharashtra, and Mumbai has this unique problem, car parking. It's a massive problem for all of us. There's a Supreme Court directive which says you cannot sell car parking, but still a lot of car parkings do get allotted. They do get, we pay hefty premiums to get these car parks. Now, we also know that there are RERA cases filed with respect to non-allotment of car parks or mis-selling of car parks also. So how does RERA contend that, given what the Supreme Court order is, and how does RERA contend with the same in the issue of car parking as on date? And what is your take on this? If you can give us a clarity on this, it will be very helpful.
Well, Ajay, before coming to this particular question, I would like to make one or two comments on the earlier discussion, if you allow me that.
Yeah, of course, please, sir.
One is Consumer Forum and RERA, in fact, in RERA, there is a provision that one can go before Consumer Forum, and those home buyers who had gone earlier to Consumer Forum can also approach RERA authorities. Okay. We found out that many complainants who had lodged their complaints with the Consumer Forum, they came to RERA, to RERA authorities. So one reason is that it provides a speedy mechanism of redressal of your grievances.
Okay.
The complaints are dealt with in a time-bound manner and have to be disposed of within 60 working days. Of course, it takes more time, but still we try to dispose of the complaints as early as possible. So that's one reason why many, home buyers, they came before RERA, and they found out that their complaints were processed and disposed of in a time-bound manner. So that both the mechanisms, both the platforms are available to the home buyers.
Right.
Second is rehabilitation projects. Now, in such
Right.
cases, the rehab component of a project
Mm.
not covered under RERA because rehabilitation or major repair are not the issues which are covered by RERA.
Okay.
Now, you must have seen in many projects there is one rehab component where the earlier occupants have to be rehabilitated, and then there is a free sale component
Correct.
in which the units are sold to the buyers who are new, occupants. So the free sale component is registered under RERA. It has to be registered necessarily.
Correct. Correct.
And so RERA covers, this particular component. But there is a talk that because in a composite project, it's very difficult to separate these two components. And one component is dependent on the progress of the other. Unless you complete the rehab component, you can't go ahead with the free sale component.
Correct, sir.
So there is a talk that both the components of a project should be covered under RERA, but so far no action has been taken, no decision has been taken by the government. So as yet, the present position is that rehab component is not covered by RERA. It need not be registered, but free sale component has to be registered. Sometimes the promoters register both the components, and there, of course, we can consider the application of the provisions of RERA for both. But even in those cases, if somebody comes to us saying that he's not been given alternative accommodation, he can't be helped because there is no provision in RERA to help these people.
Sure, sir. And about the car parking, that's
coming to your question of car parking. That's a very important question, and we come across many complaints in which issues are raised relating to car parking, and under the provisions of MOFA as well as RERA, there are two types of car parkings. One is garage,
correct,
which has a roof and covered on three sides.
Correct.
So this can be sold by the promoter,
right?
Because it's a separate unit attached to a flat, and this can be sold. But as far as the open car parking is concerned, it is a part of the common areas, which have to be, common areas are given to the association of allottees or the society, and so they cannot be sold because the money has already been taken from all the buyers in proportion to their the area of their units, the respective units. So there is no question of having another sale of car parking, which is open car parking. So there have been many litigations, and there was also one Supreme Court judgment delivered in 2010, in which this issue has been dealt with at length, and it has been held that the car parking cannot be sold; it can be allotted. So now in MahaRERA also, in the model agreement for sale, which we had revised, we also made a provision of car parking and location of car parking, the area of parking, because that's also very important. And there have been so many litigations on these issues, like the size is small and it's a mechanized car parking. I mean, the builder had promised open, stilt parking, and different type of parking has been provided. So all these issues are, are raised during the complaints lodged in RERA authority.
Yes, sir. Advocate Santosh Pandey, this question I have for you is that increase, a lot of professionals are being held now liable for deficiency of services when a particular project is looked at specifically, right? So valuation, architects, licensing, accounting, all are under scrutiny. So if such action can be taken under professionals under RERA, and can other laws also be invoked in tandem for such deficiencies or any malicious intention? Because there are case laws where architects have been held liable under judgments under the RERA as well. So I just wanted a very brief understanding from you on this.
Strictly speaking, Section 31 of RERA is about complaint, and there are only 3 parties mentioned there.
Right.
You know, the promoter, the real estate agent, and the allottee.
Correct.
Right. So no professionals are there. Having said that, Section 11, it requires certain duties and responsibilities of the promoter. And one of those things which the key points on that are, while doing the project registration, and more than that, the updation of the status of the progress report that has to be submitted quarterly on the thing. I mean, there are documents which have to be submitted, certified by the architects, the chartered accountants,
right,
and so on and so forth. Now, under RERA, in my opinion, I mean, that will be an overreach. Having said that, the authority can always take a suo motu cognizance of such thing if it is brought to their attention. But the liability rests only with the promoter. Okay,
right,
whoever is
right.
making that. But one can always, I mean, the other laws under which one can proceed is, of course, go to the professional bodies who are recognizing and giving the certificate or the authority to those people, the professionals, for certifying documents.
Right.
Under criminal, I mean, IPC, I mean, there is Section 197 and 209. I mean, any falsification of a certificate is like giving false evidence under Section 197 of the IPC, and false claim is Section 209, where the imprisonment ranges from 1 month to 2 years. So, I mean, apart from the fact that bodies like, say, ICAI can, ban their members from practicing, like, say, chartered accountant. I'm sure similar kind of misconducts, they have the professional bodies have their own rules as well. So that's
Thank you, sir. Sorry, sir. I think we are just running out of time. So I have one last question. I do understand where you're coming from. So, I mean, you rightly pointed out that, it's just the interpretation of the Section 11 that matters the most in invoking the act against the professionals. Advocate Aruna, this is the last question of the day we have to you in the forum, is that we are talking of Land Title Guarantees Act now. Right, that already a model has been prepared. It's already sitting with the government, and title guarantees are going to be provided. Hopefully, if it becomes an act, how would this be seen in light of the title insurance requirements, which is part of the RERA, and also how will you see going forward if there is any land title issue that comes up if this act is passed? How this can be resolved, and what could be the resolution mechanism? Will it be still under RERA, or it will go into civil courts and it will be resolved under civil courts jurisdiction?
Ajay, was that addressed to me?
Yes, that's right.
Okay. So yes, that's, this is one of the interesting features of RERA, that there is insurance prescribed for even defect in the title. However, in India, this is not recognized till now, as part of, as any title insurance is not there. And in case, this is being, in case this has to be implemented, then yes, the action will lie under RERA, as well as the concerned forums where the Insurance Regulatory Authority and other civil courts as well. But then this is something that has to evolve, and the first steps haven't even been taken up till now, and the insurance this has to be taken up. This hasn't come into force at all. So this is a very novel concept, and this is very much required, because that would really bring in a revolutionary.
And how do you see this Land Title Guarantee Act, that the land titling and rules that have been now formulated and at least in draft stage? How do you see that having an impact, and whether RERA?
This would definitely have it would be very challenging, and it will face a lot of difficulties for implementation, because the parameters to be brought in to really ensure title is something very difficult. Even I can tell you, at least from the experience of being in a city like Hyderabad or Mumbai, we can definitely understand that is something that is going to be very difficult, and the insurance companies, we have to see how they will really come up with the guidelines. So there have to be certain guidelines that need to be framed. for insurance of the property. This is going to be very novel. And,
thank you for that. Thanks a lot, illustrious speakers. A lot of insights, lot of thought processes that have come out. Of course, we quoted a lot of case laws. I would like to tell the viewers all these case laws today that have been highlighted by our eminent speakers are available. Please do go through. A lot of wealth of information is available out there. Thanks a lot again. Sapna, if you can take over, if there are any audience questions, we can have our speakers.
Yes, I
address
think
them.
RERA is a topic where everyone has a lot of questions still. So one question that comes is about, we are talking about the builder-buyer model agreement. Is there some scenario of, model agreement between the buyer and the broker, something like that in the pipeline? Anyone who would like to take that?
So at least I have not come across that in my study of this particular thing right now, because right now
Vivekanand, you
even
think
the
that
builder-buyer agreement is a model agreement. It has not come into practice. So
The idea of RERA is to protect the interest of buyer and as well as to some extent the promoter.
correct.
Agents, it's only a regulatory act for the agents so that they put the buyers to the correct projects and they don't misuse the buyers or take the buyers for exploitation. That's the only scope of the agents are concerned. But as regards the promoters are concerned, there are a lot of obligations and performance which are to be done. So the regulations or the scope of promoter is entirely on a high scale compared to an agent. So hopefully after this discussion, they may think of putting that agreement also in place.
Okay. And another question is about the financial institution. Should banks also come under the purview of RERA? Because they're also, it's like a three-party agreements mostly.
So I
So the
think that
banks
was
are already, sorry, back, Ajay, can I go?
no, Santosh, I think we covered this in extensively the
I
mid
think
part
we
of
have already taken that that banks, the moment they walk into the promoter shoes, and promoter's definition is very wide. Okay, and in fact, there is an order from the Maharashtra RERA that even an investor in a real estate project,
I think this question comes from a buyer's perspective. I think as a borrower from a bank. So
yes, the moment they have the controlling stake in the project, they are party to the.
See, one of the important objectives of RERA is the timely completion of the projects.
Right.
And for that, not only the financial institutions and the banks, but also the planning authorities should be brought under the purview of RERA. So that is one of the many suggestions which have been made. And I think there could be a serious thought on these suggestions.
Yes, exactly. That we got also, a lot of question on that, how these municipal authorities, approval authorities need to be also, made accountable under RERA. So I think, wonderful discussion. This is something that we can talk about quite a lot, and given the number of questions that I have in front of me, but we will definitely take them online. Thanks, Mr. Sharma, for that wonderful moderation and bringing the best out of our speakers today. Thanks, Mr. Vivekanand, Mr. Santosh Pandey, and Farid Karachiwala for joining us here today. Dr. Vijay Singh for being part of this session, and Aruna Kumari for being part of this discussion and sharing your very valuable views. Thank you everyone for this wonderful and informative session, and for taking the audience questions as well.
Thank you.
Thank you everyone.
Thank you. Thanks.
So this was our last and very interesting, very informative session of this Realty Plus Real Estate Conclave. With that, we conclude our first edition of Realty Plus Masterclass presents Real Estate Legal Conclave 2023, the virtual series. Our sincere gratitude to all our expert speakers of the day for making this conclave so informative, interesting, and not to mention a very thought-provoking one. A big thanks to the awesome audience as well for being here with us today and sharing their queries. And last but not the least, thanks to the team Realty Plus for putting together this show so wonderfully. We look forward to seeing you all very soon and have the opportunity of connecting in person too. So thank you everyone once again, and God bless. Have a great evening and a great weekend.
Thank you.